My name is Roman. I work as an international relation coordinator at the Center for Civil Liberties, Kyiv-based NGO, 2022 Nobel Peace Prize recipient. And with today's webinar, we are opening a series of events called International Criminal Justice Week. It is dedicated to honor July the 17th. This day is set in commemoration of the adoption of Rome Statute of the International Criminal Court, the first ever permanent body of international justice with a jurisdiction directly under international law to prosecute the most serious crimes, war crimes, crimes of the genocide, and others. And for the fifth year, for the 5 times already, the Center organized the International Criminal Justice Week. This year, the topic of our events called How to Break the Circle of Impunity. In the course of the week, we will cover various aspects of international humanitarian law, international human rights law, and international criminal law. So during this week, we will have not only webinars like that one that we start today. We will also feature a film screening, a workshop, and a big conference happening this Wednesday, the 17th of July. Our previous webinars are available on our YouTube page, which I share in the chat. The International Criminal Justice Week agenda is visible in the event webpage that is also at your screen in the chat. This video will be recorded and you can revisit it for educational purposes afterwards. Today, our speaker is Professor Devід Kеттін. He is adjunct professor of international law at the Center for Global Affairs at the New York University, USA. And he is also an adjunct professor of Law of International Organization, Faculty of Law, University of Verona, Italy. Center for Civil Liberties and Professor Devід Kеттін have partnered on various occasions in the past concerning the Rome Statute adoption and the promotion of legal, political, and societal benefits of international criminal justice system and the principle of universal jurisdiction. So after the short lecture, you will be able to ask your question during Q&A. You can raise your hand, tell your name and occupation, and ask the question, or you can type the question into the chat and I will voice it for you. Professor Kеттін, please, the floor is yours.
Thank you very much, Roman, and it's really a great honor for me to be associated once again with the Center for Civil Liberties. We work together since 2014, and there was a partnership that I was so proud to forge on behalf of the Parliamentarians of Global Action between 2016 and 2021, which really saw us working together. And honestly, what happened with the fully fledged invasion of Ukraine on 24th of February 2022 brought us to review what we had done in the previous years and to try to discuss also with others and with other stakeholders and institutions what didn't work, so that the situation escalated to the level of violence that unfortunately you're experiencing today. And needless to say, I was a big supporter of the Tribunal for Putin project championed by Alexandra Matvichuk and all the team at CCL and all the other NGOs that in Ukraine have embarked in this incredible operation of searching for, detecting, keeping, safeguarding the chain of evidence of the mass atrocities that are committed in the entire country at a level that I believe it's really unprecedented, and that will need to make sure, and it's our imperative that this should happen, that any peace in the future that is deserved by all concerned will be a just peace based on a principle of justice. International law entails the principle of self-defense, which is inherent. No one can remove it from the Ukrainian people. It's an inherent right of self-defense, whether the weapons are delivered or not, whether they are given on time or not, whether there is a president of one country or another president, whatever happens, that right belongs to the Ukraine as a state and also as a people, because the rights of states are conferred for the betterment and the protection of the rights of the communities and individuals who live in any national society. We don't believe in international law anymore, in these abstract entities who are ruling our international society. The state serves us. It's not us serving the state. We are the state. We are the community of the nations made of us, communities of individuals. And the sovereignty of state is a value only if the sovereignty is used to serve our own fundamental human rights in all the capacities that we might have under both international law and constitutional law. So what has been done during these years is really impressive, and I really want to, at the outset, express my strongest support for the work of CCL and all the organizations involved in the a Tribunal for Putin coalition, 4 AM coalition, and all the incredible work that is being done in Ukraine on fighting against international crime. So this war didn't start on the 24th of February. This war started in 2014 with the illegal annexation of Crimea, which was an act of war, and also with the eruption of these two self-proclaimed entities in the Donbas, the Lugansk People's Republic and the Donetsk People's Republic, which were, since the very beginning, the emanation of foreign interference in the domestic affairs of a sovereign state. And these conflicts started as an international armed conflict, not as a non-international armed conflict. As it has been also affirmed by the International Criminal Court when it analyzed the context within which the initial analysis of the situation was taken care of by the prosecutor of the second prosecutor of the ICC, Fatou Bensouda. What has happened is, let us make then a step back vis-a-vis the system of how does this system of international justice. We are celebrating the week because of the 17th of July, 1998, where in my own city, where I'm connected from, of Rome, the statute of the International Criminal Court was adopted with a vote of 120 states, including Ukraine and the Russian Federation voting in favor of the adoption of the Rome Statute, 7 votes against and 21 abstentions. Today, the Rome Statute has 124 state parties, and still approximately 70 members of the UN didn't join. The Russian Federation signed the Rome Statute at the end of the year 2000, but in 2016, it sent a letter to the Secretary General of the United Nations invoking Article 18A of the Vienna Convention of the Law of Treaties. Therefore, as a signatory, the Russian Federation declared not to be bound anymore by the political commitment not to defeat the object and the purpose of the statute. This was in response not of the Ukrainian situation, but of the investigative developments relating to the Georgia situation of 2008, when it became evident in 2016 that the prosecutor of the ICC would have proceeded with a fully fledged investigation in connection with some war crimes and crimes against humanity attributable to the responsibility of Russians or Russian-sponsored individuals. And at the moment, there are 3 pending arrest warrants for those alleged crimes committed in 2008 during the Russian occupation of large segments of the territories of Georgia. So, but what happened when the Ukrainian situation changed, when Ukraine decided to move towards entering into an association agreement with the European Union, because this was really the main cause of the decision of the Russian Federation to annex, abusing of the Budapest Protocol, making use of its troops in the Sebastopol port, making them change, remove the uniform and putting them as fake civilians to organize a referendum that then provided some sort of facade for the annexation process. And then in parallel to support the two secessionist republics. Well, what happened then is that the people of Ukraine, through a transitional Rada that had changed the balance of power, decided that it was more important for Ukraine to join in the long term, and not immediately, but to enter into a process to join eventually the European Union, rather than remain within the framework of the Commonwealth of Independent States, the CIS, the international organization created on the as a replacement of the Soviet Union. That very moment marked the commencement of an international armed conflict. And probably the main contradiction was that in the responses from the international community, including from the Ukrainian government, that very situation was identified as a case of terrorism, at least in respect of the two secessionist republics. But it was not terrorism. Terrorism is something that exists everywhere. It's a phenomenon that you find in every little country of the world. You can kill one person and you can commit an act of terrorism. This was mass criminality of a magnitude that is much more serious, as we have seen with the cases relating to the arbitrary imprisonment, the torture, the rape, the killing of civilians. So this pattern of war crimes undoubtedly started in 2014. The response from the Rada was to request to the government of Ukraine to accept the jurisdiction of the ICC. At a moment in time, at the end of 2013 and then again in 2015, at two moments in time in which it was not possible for Ukraine yet to join the International Criminal Court because of a Venice Commission report dated 2001. The Venice Commission is an expert body of lawyers within the Council of Europe, which stipulated that in light of the Article 124 of the old constitution of Ukraine, Ukraine could have not joined the Rome Statute unless it would have accepted the jurisdiction of an international criminal court, as, for example, France and Portugal had to do by amending their national constitutions before to ratify. So it was nothing new. It was a purely legal, technical opinion that was given. But over the years, a number of governments didn't take any action to ensure that those provisions could have been modified, could have been amended. This happened only during those years between 2014 and then on to 2016, when you already had a president-elect, Mr. Poroshenko, that created a commission of experts, which included the revision of Article 124 in the package for the reform of the judicial system. Yet, when this became a document delivered to the Rada at the beginning of 2016, we found out at the very, very end of 2015, the presidential office included a provision to postpone of 3 years the entry into force of this particular amendment, while all the other amendments had immediate entry into force upon adoption. This one was sequenced for 3 years after entering into force, which actually would have meant under the following president, following Mr. Poroshenko. So this somehow sent a mixed signal to the world that Ukraine was not so committed to accountability as the Rada would have wanted when it requested to the government to accept the jurisdiction ad hoc under Article 12, paragraph 3 of the statute. And the second acceptance of jurisdiction extends the jurisdiction of the ICC to any crime falling under the Rome Statute committed in the territories of Ukraine since February 2014. So in a sense, Ukraine, the territory of Ukraine is already protected by the Rome Statute system. But the Rome Statute system is based on state consent. It's a treaty base. It doesn't apply universal jurisdiction. Cannot take any case in any place of the world. And the only modality to impose the jurisdiction of the court against the will of state is through Security Council referrals under Chapter 7 of the United Nations Charter, which is unfortunately a very politicized modus operandi for international justice, because the Security Council operates through resolutions adopted by a majority of 9 states out of the 50 members, with the concurrence of the 5 permanent members in the Council. And what had happened in May 2014, let's not forget about this date, which is crucial to the escalation of violence and the eruption of the conflict in Ukraine. In May 2014, 13 states, led by France, prepared a resolution to refer the mass atrocities committed in Syria by anyone against civilians and other protected persons in Syria. That included the Russian Federation army at the highest level, because the siege of Aleppo and a number of carpet bombings against rebel cities in Syria, not Damascus, were carried out directly by the Russian Federation aviation, with a military base in Latakia and the intervention of up to 58,000 foot soldiers in the war in Syria. Well, in May 2014, the Russian Federation vetoed the referral, supported, unfortunately, by the People's Republic of China. So that created a total impunity zone for Mr. Vladimir Putin, Mr. Gerasimov, and all the main leaders of the military operation in Syria, which brought about the death of hundreds of thousands of civilians, mostly attributable to the armed violence of the Bashar al-Assad regime supported by Russia, Iran, the Hezbollah, and other militias forming part of that deadly coalition. Of course, you had also the Islamic States, or ISIL in the north of Syria. So you had a number of other actors committing mass atrocity crimes, including an attempted genocide against the Yazidi minorities. A very complicated and complex conflict where Western powers led by the United States intervened with the Operation Inherent Resolve to try to save the lives of the Yazidis and other minorities in the north, with the support on the ground by certain rebel groups. To cut a long story short, in Syria, Vladimir Putin and the leaders of the Russian Federation managed to create a total impunity zone. And the responses by the international community to what was happening in Syria did not sound so strong as a way forward for accountability and justice vis-a-vis the prevalence of violence and atrocities. This was also, to a certain extent, partly related to the failure of the Western bloc of states that gained a majority at the Security Council in 2012, when they referred the situation in Libya to the jurisdiction of the ICC, but in parallel obtained a resolution, 1973, to create a safe skies, a no-fly zone area, and a mandate to protect civilians on the ground, which was unfortunately largely abused by some NATO states, which instead of just protecting the civilians ended up supporting fully the rebellion against the Gaddafi regime, which then led to a response by the Russian Federation and its allies to then block each and every future action in the name of the doctrine of the responsibility to protect the civilian population within the council, including any future referral to the International Criminal Court. So, unfortunately, the geostrategic situation in 2014 was as such that justice and accountability were severely weakened by many years of erosion of the international legal standards that we had built in Rome 1998, entered into force in 2002, and started to operate, even though with a lot of difficulties, but to operate in a number of conflict and atrocity situations. Just to complete this framework, of course, I cannot not mention the tragic developments of the so-called war on terror, which instead of weakening terrorism, ended up by catching in the middle hundreds, if not thousands, of innocent civilians in many parts of the world who died out of the use of armed drones or other weaponry. And unfortunately, that left so much grievances and so many complaints that international law was being violated without accountability for the perpetrators of these violations. And of course, the failure to bring to justice individuals who were guilty, who would have been, if found guilty beyond reasonable doubt, convicted for the crimes committed on 9/11 and other major attacks on civilians in the previous decade. Well, that was some sort of a framework in which the idea was that revenge or violence was replacing violence and accountability. That also weakened, eroded the international legal framework and created a larger space for dictators like Vladimir Putin to sort of strategize in an alternative way, Then what happened after that the conflict started and the situation was activated before the International Criminal Court, at least in terms of preliminary analysis or preliminary examination, is that probably the response was also very weak and contradictory. First of all, the Minsk agreements contained an article which related to an arrangement between Ukraine and the Russian Federation, or the secessionist republics with the Russian Federation. They contained, these Minsk agreements in their two versions, an Article 5 that suggested, although not directly but indirectly, that there would have been an amnesty for the violence associated with the armed conflict. Would that mean that that violence included war crimes? The question was open at that time, but the message was sent, a negative message, that impunity could have been created within the scope of a peace settlement of the ongoing situation in the Donbas and in Crimea. And that was certainly a weakening message for justice and accountability. And then, of course, while the International Criminal Court took many years to analyze the situation, it received negative signals from certain powers who were engaged. At the same time, they were sitting as a member states of the ICC, as state parties. They were seeing that Ukraine was not joining as a state party, because I told you about the postponement of the entry into force of the transitional provision of Article 124. So the message was always mixed. Yes, justice, yeah, Ukraine wants justice, yes, but not now, maybe not now. So it can be postponed. And these somehow send the signal that, well, this ICC is some sort of a paper tiger that will never have an impact on this situation. Ukraine at the domestic level will not be able to bring to justice the perpetrators from the Donbas and also from Crimea, because there is Article 5 in the Minsk agreement. And at that point in time, also universal jurisdiction and other mechanisms were quite weakened. Now they are resurging, they are being resurrected by many states. But we had a period of crisis of those laws. So here we go to the time 2010, when prosecutor Bensouda finally presents a very convincing report to the Assembly of State Parties, saying that the preliminary examination was going to end positively, because the level of criminality in the Donbas and in other Ukrainian territories was so grave, and under domestic jurisdiction, complementarity didn't work. ICC complements domestic jurisdiction. Domestic jurisdiction didn't tackle criminality cases at the highest level in these regions. The prosecutor notably also mentioned that she received much documentation a lot of documentation from the Russian Federation on alleged crimes attributable to the responsibility of Ukrainian agents, which, of course, she said, I took note of it, but no action, because, of course, we know that that was mainly propaganda and fabricated evidence. But what does this mean is that I would have expected in 2020, not 2010, 2020, that finally Ukraine would have joined the ICC. It was in the electoral platform of the party of President Zelensky. It was the majority of the Rada agreed to this. We had leaders from the Parliamentarians of Global Action from both sides of the political spectrum. Nevertheless, these didn't materialize. And Ukraine remained some sort of an observer in the Assembly of State Parties. And in my humble view, as I said in the Duma on behalf of Parliamentarians of Global Action in 2018 and 2019, it's like when you take a bus and you don't pay the ticket. You want to ride the ride, correct? You want the court to make its job, but not as a state party, as some sort of observer who watches and sees. If you like it, what the court does, we'll applaud. If we don't like what the court will do or will not. So it was weakening. The ICC in The Hague is a treaty-based institution. If you don't join it, why should it work for your benefit? It should, because under the law, it should. But it's a fact of life that in all its history, the court has given priority to cases and situations in the territories of states that had ratified the Rome Statute or where there was a Security Council referral, so with the mandate coming from the entire international community under Chapter 7 of the UN Charter. So these delays really were self-defeating and, again, weakened the stand of Ukraine. Then we go to what happened in 2022. And what happened in 2022 is really the manifestation of a regime that believes, the Russian Federation regime, that believes that nationalism or imperialism can have a second life in our history. These are ideologies that comes from the 18th and 19th and 20th century that we thought they had ended with World War II. And that's why the reaction was so much in support globally to the stand of Ukraine, because we hadn't seen a permanent member of the Security Council to launch a war of aggression and annexation on a neighboring country yet since 1945, since the UN Charter was adopted. And then we have immediately a reaction by many states, more than 45, from all regions of the world, referring the situation of Ukraine to the ICC. We have the mobilization of resources, because the ICC undoubtedly has been underfunded by member states. Some critics say that the court budget is high. Listen, it's a budget of 150 million per year. How many F-16 can you buy with 150 million euros? I don't think even one. So, I mean, you have to relativize the cost of justice vis-a-vis what is spent for security, defense, the rule of law, you name it, so unfortunately, these criticisms, unfortunately, were instrumentalized to criticize and limit the court. Today, we live in a different scenario. To cut a long story short, we have two very prominent cases already that are more than 1 year old from March 2023 against Vladimir Putin and Commissioner Belova on the issue of the Russification of children. This is a crime that sort of was showcased, broadcasted live on national TV by President Putin, who signed on decrees to render these Ukrainian children Russian. This is in violation of the Geneva Conventions of customary international law. It's a war crime, and it can also be qualified as a crime against humanity, because you have to deport, you have to transfer forcibly those children who don't belong to you. They belong to their families in the occupied territories. Because what we are seeing now in Donbas and in Crimea and in other regions, Zaporizhia and so on, are occupied territories. So the prosecutor can, and all the evidence, it doesn't need any witness. If it's real, what the president did, and if it's true what happened, you don't need a single witness. We are like in a Nuremberg trial, Einsatzgruppen case scenario, where prosecutor Ferenc secured the conviction of all the leaders of these special forces who killed 1 million civilians. That he selected only 1 million victims. He could have gone on and selected more, but he stopped at 1 million victims. And they were all convicted without a single witness being called, because they recognize as authentic their signatures on the execution orders for all the people they killed in Poland, Lithuania, and so on and so forth. So, and then we have at least other 2 public cases, but as far as I know, there are at least 10 or 11 cases. We have cases relating to the destruction of the energy plant, which are seen both as a war crime targeting civilian objects, but also as inhuman acts under Article 7, crimes against humanity, because these creates unnecessary suffering, superfluous pain and suffering to the physical and psychological integrity of the civilian population of Ukraine. You don't win a war if you have a shortage of energy in Kharkiv or Kiev or Lviv and so on. So it's certainly what we are witnessing now is a war conducted with the old idea, 20th century or 19th century idea that you can win the war also by breaking the morale of your opponent, which justifies, things like carpet bombings, targeting civilians and so on, so that I think it's a wrong calculation. I think the more atrocities the Russian Federation agents will commit, the more there will be resistance, and the more there is a prospect for those who are in power to lose power, and not with honor, because they should be brought to justice. The main challenge, of course, so the standard, and I've not mentioned the arrest warrants recently issued against Gerasimov and Shoigu, the Minister of Defense and the former Minister of Defense and head of the army. But I understand there are many other investigations going on, and the arrest warrants are kept secret by the pretrial chamber for a very good reason. If you read Article 68, paragraph 1, all the organs of the court, including the judges, they have an absolute, unconditioned obligation to protect witnesses and victims. Now, some of those victims and witnesses, they are in the occupied territories. Maybe some of them that are even in Russia. The moment these documents become public, the accused person might find out who is who could be the witness, who could be the survivor who survived the rape, and they can go there and kill her or kill members of her family, or do in a way that the evidence will be destroyed. So that secrecy is key. We shouldn't be frustrated with it. We know we love we lawyers, we love public trials. We are not yet at trial level, of course, but these materials must remain sealed, must remain confidential, because the court cannot protect anyone if they are under the jurisdiction of an aggressor state. Of course, the biggest deficiency of the Rome Statute was caused in 2010 by the Kampala amendments. And unfortunately here, notwithstanding CCL now received the wonderful support of a number of states, I must be very honest. And here this was, we Europeans and Africans and Latin Americans and Asian member states of the Rome Statute, we gave in to the Obama administration request to give immunity or to have an exemption from jurisdiction for the nationals of states non-parties. And we have in Article 15 bis on the crime of aggression that nationals of non-state parties cannot be prosecuted. And this is the ultimate benefit for Mr. Putin, who cannot be prosecuted for the crime of aggression before the ICC. So we have a big debate on creating a new Nuremberg at a time, of course, in which we cannot create any new Nuremberg because we are not in 1945. There is no victor, There is no occupation of Germany. There is no zero ground. There is no new law to be created. We need to apply the existing law, including Article 8 bis of the Rome Statute, which provides us with a consensus definition of the crime of aggression, which was agreed by all, including all the UN member states who attended the Kampala conference and could have given an alternative definition, and they didn't. So what we need to do now is, yes, to create a transitional jurisdiction that can apply crime of aggression, which is the mother of the crime in an international armed conflict conducted with aggressive intent, which is the war of aggression against Russia, against Ukraine, which started in 2014, not in 2022. And of course, when it started in 2014, the Russian Federation leaders, they knew about the Kampala Amendment of 2010. So, you know, everything is connected. And of course, they knew. And I haven't been self-critic here with my own country, Italy, and the entire European Union. We have been too timid and too generous with the Russian Federation in terms of their entry into the European economic markets, especially the one of oil and gas. And we have allowed Russia to grow as a superpower in this field without imposing any human rights conditionality, notwithstanding the fact that Russian Federation was a member of the Council of Europe. This didn't support any maintenance of democratic institution in the Russian Federation as they were growing in the 1990s. So I think what needs to be done now is not to create an ad hoc tribunal that is totally separated from the ICC. This would be, in my view, in my humble view, a mistake. We need an international jurisdiction, as it was recently affirmed by a statement that was endorsed by the Ukrainian Bar Association. So it has to be, and with the International Bar Association, it has to be international in nature. It cannot be an emanation of the Ukrainian system. Also, it would be unconstitutional for Ukraine to create a special tribunal under the current constitution. It can be drafted as it is being done now within the framework of the Council of Europe. That's no problem. There are many member states of the Council of Europe, and the Council of Europe can adopt treaties that are open for ratification by every state of the world. But the law applicable before the special tribunal must be the law of the ICC. The special tribunal must cease to exist the moment in which the ICC jurisdiction is aligned for the 4 core crimes, which is on the basis of a proposal that Germany and a group of like-minded states is going to table very soon, hopefully after tomorrow, the 17th of July, or in the following months. And by the 17th of July, 2025, we will have these amendments of the amendments to be discussed by a review conference or a special session of the Assembly of State Parties, so to fix this wound that was created in Kampala. And at the same time, in my humble view, it would be ideal if this treaty creating a special tribunal would be endorsed or even replicated as an additional protocol to the Rome Statute by the Assembly of State Parties to the Rome Statute. In other words, it can be born as a Council of Europe treaty, but to be universal and to be mutually reinforcing the mandate of the ICC, in my view, it should also be adopted as an additional protocol to the Rome Statute, which will expire the moment in which the jurisdiction of the ICC will cover all the crimes of aggression committed by anyone against the territories of state parties. In the meantime, of course, Ukraine should ratify. And here I'm very happy to note, and I will finish my talk with this happy note, that I've heard that one of the top officials in President Zelensky's team finally 2 days ago announced on Voice of America that she's working, the team is working on getting Ukraine to ratify the Rome Statute by the end of 2024. This would be an excellent news. It runs contrary to the statement of August of last year, in which another high official said that Ukraine would have joined the ICC only after having won the war. And, you know, this is not good. If you wait until the outcome of the war, it means like, oh, let's wait and see. If we win, then as a winner, we decide what to do with our restored sovereignty. The full sovereignty of Ukraine applies today. It applies in Sebastopol. It applies in Donetsk. It applies in Lugansk. It applies everywhere where unlawfully there is a piece of territory that does not belong to the occupier, but it belongs to the people and the constitution of Ukraine. So there is no need to wait that your sovereignty is fully restored in the sense of public international law, because on a legal plane, the sovereignty of Ukraine applies to all the people who are unlawfully occupied, unlawfully Russified, and so on and so forth. So I'm here open to any question, and I know you have a number of very interesting questions. And thank you so much for having me again.
Professor Kеттін, thank you for providing us both historical overview and legal analysis of Rome Statute and international treaty regarding the crime of aggression and other grave violation of international law. So, dear participants, you are free to raise your hand and ask the question, or to text your question into the chat. In the meantime, I would like to voice a question that we receive during the registration process. And the first question is really broad. Professor David already tackled some of this question already, but I would like to single it once again, just to make a small overview. So the first question is, what are the practical ways of prosecuting and bringing to justice Russian war criminals do you see? Do Ukrainian authorities do enough to bring to justice the Russian war criminals? And what can they do more? How Ukrainian society may effectively enhance the process?
Okay. You know, practical ways to advance the accountability, we are witnessing them every day. I cannot tell you that there is more than it's being done. I think a lot is being done, a lot also in terms of coordination. Colleagues are speaking about an ecosystem of the fight against impunity or international accountability being established in and around Ukraine. So I think a lot is being done. What probably can be done more is a little bit controversial. And it is to also be able to create positive incentives for those who want to defect the Russian Federation aggressive war and somehow collaborate with justice. So maybe this is already happening to a certain extent, but for this strategy to be weakening those who are supporting the war effort, probably we need a bit more. We need a bit more in terms of international support, of capacity to, let's say, also link better the individual sanctions, the targeted sanctions, with the efforts to impose, to promote and affirm criminal justice. So, for example, instead of travel bans, we should have travel incentives for those who, you know, why should we ban the travel of certain people? We need to arrest, am I right? So, but we don't need only them to be arrested because they have to be brought to justice, like the individuals who are already named, like Belova, Gerasimov, Shoigu, and the other generals, and of course, Mr. Putin. But we also may need somebody else to travel who can give the evidence, who can also invite others to change their mind. So create some sort of more soft movement towards collaboration with justice, making use of these incentives. I think what can be done more, of course, is what I've already said, which is for Ukraine to join the ICC as a fully fledged state that can elect judges, that can have a seat in the decision-making process towards amending the crime of aggression, that can have, you know, also the commitment to be there for good. Because we have seen in history so many mistakes being done by those who are liberating their nations. Certainly Ukraine will not want to make the same mistake. So being part of the Rome Statute is a guarantee of non-repetition for the future. of what we are witnessing today. And I think that commitment will be very well welcome. And finally, it's really a precondition for EU integration. So I think all of these, and then finally, let me tell you something that I didn't say, which is that Ukraine believed in international law because Ukraine gave up its nuclear weapons in exchange for Russia to respect the territorial integrity and the political independence of Ukraine with the Budapest Protocol, which Russia violated. And after that, it violated it in 2014. What was the sanction against Russia? Very weak. So so I think more has to be done, of course. I think the lesson has been learned, but, you know, hopefully it's not too late, and we need to plan for the future so that whenever peace will be feasible, then there will be guarantees of non-repetition.
Professor Kеттін, thank you for your answer. Dear participants, we have 10 minutes more. If you would like to voice your question, you have time to prepare and ask. And I will move to the second one, received in the chat. What are your thoughts on certain restorative justice practices that have been previously used in international conflicts, as well as amnesty privileges for the former heads of the Luhansk and so-called Luhansk and Donetsk people republics? So the question is controversial because it's tackle the body of law called restorative justice, which should not be messed up with transitional justice.
Let me say this. I prefer to speak about reparative justice, not restorative justice. Restorative justice is very much towards the accused. Reparative justice is much more sympathetic to the victims or those who suffered injuries and terrible pain and suffering as a consequence of the crime. Clearly, criminal justice is not the answer to all the problems or to most of the problems. It's one of the many answers. And when we talk about, you know, when I've seen what happened in Bucha, what happened in Bucha was an eye-opener for us in the West. Not for me, I knew about it, but for many people who would not believe that the Russians would have behaved like they did in Bucha. Okay, and then we saw Mariupol, even worse. You know, Mariupol probably is the worst crime scene that we'll need to open up one day. But I think the issue is that many atrocities were committed by individual soldiers who took advantage of the lawlessness of this order of leaving Bucha and then do whatever you want to do with it, and then loot and rape and kill and so on. Okay, so while some of those individuals should be punished because they did it intentionally, others might be probably better taken care of if the victims, of course, are involved in this process. It cannot be just dictated from the top with conditional penalties, for example. You have the Colombian jurisdiction for peace that provides with a model in that respect. Of course, this type of approach to justice is one that you can plan for the post-conflict situation. So I think today is too early to speak about it. Insofar as amnesties are concerned, certain states proposed the inclusion of amnesties in the Rome Statute, and almost every state was against. So it was not even put on the table because no state would support it. So crimes against humanity, genocide, war crimes, and the crimes of aggression cannot be as such amnestied. Yet there can be some form of lenience or forgiveness, measures of forgiveness or clemency insofar as the imposition of penalties is concerned, insofar as the post-investigation and prosecution phase is concerned. So not amnesties on the crimes, but maybe some forms of leniency or amnesty on the penalties at a later stage, yes.
Professor Kеттін, thank you for your response. And I would like to voice maybe the last question for today. What can you tell about ECPA, International Center for the Prosecution of the Crime of Aggression Against Ukraine, and the way it cooperates with national prosecutor institutions?
This was a very interesting project when it was launched. I was very supportive of it. Essentially, this is a body created within the framework of Europol, all right? So there is a body, it is based in The Hague, where you also have the ICC, the international tribunals, the International Court of Justice, so it's an appropriate venue. But it's within the framework of a European Union police organization. Yet it is open to non-parties, and there is very strong presence of the United States and other allies to Ukraine. Now, the idea is that this center collects and preserves the evidence of the crime of aggression. It consists of prosecutors that are sent by all the EU member states, plus Ukraine, the United States, and if I'm not mistaken, maybe a few others like Switzerland, if I'm not wrong, but I don't know exactly. What counts here is that anything that this body does is only a small segment of the entire equation that we need to see for accountability for the crime of aggression. So if they are able, as they should, I visited their offices, but of course they work in total confidentiality, so I had only a meeting with the head of the EU Genocide Network a few months ago. And my understanding is that they operate in a collaborative way with Ukrainian authorities to try to analyze how the war of aggression developed and track, I believe, some of the sources of this war of aggression. So we are not yet at any stage of evidence gathering in concrete terms. It's more like sort of the context and the study and sort of being ready to then access the evidence when it will be, when there will be a body where this evidence could be used. In my view, when we create a special tribunal for the crime of aggression, and ideally it should be not only under the Council of Europe, but also under the Assembly of State Parties to the Rome Statute, so universal, then we should allow the European Union to ratify the treaty establishing the special tribunal, so that Europol and the International Center for the Prosecution of Aggression are part and parcel of the constitutive elements of this new tribunal. So if this is what will happen, I think it will be very beneficial. If it's just, you know, a group of people who meet time by time, then it's not enough. I would argue that they should maybe be more visible and come up with some sort of statement or illustration of what they do, because it would be nice to know more about their activities. I know that Ukraine is certainly involved. The Prosecutor General and the state of Ukraine is involved, but it would be better to see this entity to have a bit more of visibility and public profile insofar as what they do. Certainly they can be an essential element of this new special jurisdiction that can tackle impunity for the crime of aggression.
Professor Kеттін, thank you for your answer. There is no pending questions in the chat. So I would like to briefly explain that this Friday we will host another webinar dedicated to the creation of a special tribunal for the crime of aggression. And the lecture will be taught by executive director of a big US law firm, PLPG, Public International Law and Policy Group. Therefore, our dear participants, dear students, you are more than welcome to register and participate in the event next Friday, which will occur at 1 p.m. Kyiv time. For today, dear speaker, dear students, we are officially finished. It was interesting and beneficial for us all. And I hope this lecture information that you get to know today will positively influence your work and studying activities. Professor Kеттін, we are always happy to work with you. Thank you very much.
Thank you very much. And I really, you know, all my solidarity and support. And I think you know, we are all close to your cause, and we continue to fight. Thank you so much, Roman, and thank you so much to the Center for Civil Liberties.